The HR Stories podcast is brought to you by the team at HR Stories. The team at HR Stories helps businesses, nonprofits, and HR practitioners better manage the employee experience, providing the tools, training, and resources needed to get HR right. For more information, check out our website at theteam@hrstories.com. Each week on the HR Stories podcast, HR and leadership experts John Thalheimer and Chuck Simikian dive into the stories that matter most to you, our listeners. We have found that there is a lesson in every story. And now our host, John Thalheimer and Chuck Simikian. Welcome to the HR Stories podcast, where there is a lesson in every story. My name is John Thalheimer, and I am in here with Chuck Simikian, better known as HR in Paradise.
HR in Paradise. Whoop, whoop. Yeah. Well, the Paradise part comes from moving from Orlando down to the Florida Keys. It was a 30-day assignment, folks. And that was in November, and I got stuck. Got stuck in the Florida Keys. No, not in quicksand. Not stuck in 3 feet, 10 feet of snow. Stuck in I don't know what. So yeah, I'm sticking around for a little while longer.
I gotta say, I don't think any of our listeners are feeling sorry for you.
Yeah, well, they will when they say the big hurricane season is supposed to be the worst ever. Blah blah blah. You know, that's okay. I got my bike helmet and my packet of Slim Jims, and I'm ready to withstand anything.
All right. Well, Chuck, you have to be safe down there. But yeah, it's funny, Chuck, because I know we kid that you're down in HR in Paradise and blah, blah, blah. But one of the things that I always find fascinating when I'm talking to you about what's going on and the challenges you have real life challenges going on there, right? And so even though that your location may be seeming as paradise, I think one of the things that we see a lot from you is that there's challenges. Anywhere you're working in the United States, there can be HR challenges. And I think, I don't want to go into details because I know a lot of that stuff we probably shouldn't talk about on air, but I do think, paying attention and looking at that and, having issues hiring people probably is a big deal there.
It's there's a lot of that. But, what I was telling my team today, I said, look, we're a service department, and there was a thought, and it gets a little frustrating sometimes. People come in and they could do these simple things. And we've talked about this before. Technology is supposed to make our lives easier, especially in HR, but it has not. It has made it tougher in some ways. And, these folks can do their own stuff. They can log in to ADP. Yes, they can. But you know what? We're a service department. And so we're going to take time to maybe not do everything for them, but if we have to, we will, but we'll show them. Let's show them how to log in. I could easily say, go to 401k.com and log in, or I could say, you know what? If you want to sit here at the lobby HR computer, let me show you. You have a minute? Log into 401k.com right now. Let me show you how to create your account. And that's huge. And that is something that I know a lot of my HR friends and colleagues and brethren out there do each and every day. I know our number one job is to protect the company and, compliance, all that, but it's those little things of helping people out that is huge.
Well, it builds trust up, right? I mean, it builds people want to come to you. And when they come to you, they're more likely to tell you what's going on, and you can catch the fires before they become fires, right? And so they're going to be more relaxed. They're going to feel comfortable about you. You can do that. And then it's kind of a way to build that relationship up with those individuals by serving them and helping them with their computers and that kind of stuff. So yeah, I love that you're doing that. I think it's an important task. It's an important reminder for all of us in this industry to make sure that we're serving the employees the best we can. Now, there are times that we have to tell them no, but I also think that approach is fantastic, Chuck. So I'm glad you're doing it down there.
And you bring up hiring, recruiting, and stuff. And it's funny. My first HR in the news. There's an article out there. It says the headline is less than a third of job postings require years of experience. It's from Indeed. It's a survey or something from Indeed. And basically, it's not so much the contents of this story that bring to light, but you talk about my real world experience. So this article talks about skills-based hiring over traditional educational degrees and how less than 1/3 of U.S. job postings include requirements for years of experience. But they're talking about this shift, right? Employers want experience requirements in the job rather than sometimes the degree. And there are some times where a degree is helpful and necessary, but just today, John, I pulled up, we have to hire a banquet manager, and I pulled up the job description and posting, and I put it all together, and it said a college degree, bachelor's degree, and 5 years experience. And I'm thinking, okay, I would love to get a banquet manager that came out of college as 5, 6, 7 years. But you know what? I'd rather take 5 years of experience. And if they have a degree, great. But I'm not going to make that a what's the phrase we always use? The definite requirement. There's a phrase.
Yeah.
Requirement,
and not preferred.
Yeah, it's a preferred. Yeah, I'd love to. So for me, at least in the hospitality industry, when it comes to some of those, even those management jobs, now granted, as they get higher up, but maybe I want a degree, but I got to tell you, I'm just looking for the experience and the knowledge and the skills and the enthusiasm for the craft. I rarely look at if they have a degree.
And I think that makes sense. So when I worked in the hotel way back in the day, a lot of people in the hotel got into their supervisor role because they had years of experience and they were well known and they were passionate for the job and they cared about what they did. And so they were promoted and they got the on experience, right? And so, yeah, of course, we get some degree, some positions are going to require a degree. And all a degree is saying, look, we know because you have this degree, that's a shorthand for saying, oh, you have that knowledge. But do they really? I don't know. I mean, again, right, I'm not saying degrees are worthless, but depending on what you're doing, they may not have the information you need, right? And so you're going to have to test them. We were talking about this beforehand, Chuck, and I did, for one of my clients, I did a 1-hour webinar about skill-based hiring. And I'm a big proponent. I think it's really important to think about what are the skills they need in this role that's going to make them successful and seeing if they have it. I don't care experience. I don't care degree. Do they have the skills necessary to do that? Now, sometimes it takes years to develop those skills. I get it. But we need to figure that out and not just jump to that conclusion.
Yeah. But I will tell you, though, a lot of times if I see people that they do have degrees, they do present themselves a little better just because if you can make it through college and so it does help prepare you overall in a maturity standpoint. So that is one aspect that I've noticed, but it's not the first thing I'm looking at. But anyways, what are you seeing in the news these days, John?
I got a couple stories, but there was a new study out that revealed that millennials aren't asking bosses for permission to use PTO anymore. So basically, they're just going to take the time off and not tell anybody that they're taking the time off. And again, what we're finding is that there's two parts to this study. The first part, what they said was that Generation Z and millennials were less likely to use all their time off, right? As things were going by, they just weren't using it up. And I think back to when I was younger, or some of my nieces and nephews, and I think there's a time in your life, where you're worried, or a time in your job life, I should say, you're worried about taking time off in terms of how it's going to be perceived by other people in the workplace. And I think one of the things that's really important for leaders and managers and supervisors and people in HR is for us to take our time off. And the reason I say that is because we know taking time off is important for everybody. But if we're not taking it off, the people underneath us or around us are looking, going, they don't take any time off. Is that how I get ahead? All right, well, no, I'm not going to take any time off. But what's happening, though, is people are being like, you know what? I'm going to take the afternoon off, but I'm not going to tell my boss. And so some people will use, the Slack, move the mouse around every once in a while and pretend that they're working, or maybe while they're watching a movie. And so I think there's still some of that going on. And it has to do with trust. It has to do with being able to be like, you know what, I need some time off. The article did mention that, and there's a push for this around the world, really, is to have a defined boundary for workplace work, right? And so, meaning that you're not going to be bothered on the weekend, you're not going to work on the evenings, you're not going to get phone calls in the middle of the night, right? None of that stuff's going to happen. You only work when you're scheduled to work. It hasn't got much play in the United States. I know California is trying to put something. I think Australia did something. And it will be interesting because I think so many people and so many of us just grew up in that environment where, especially if you work for a 24/7 company, like a resort, in the theater, in production, in broadcasting, you get that call and you're like, okay, got to come in. I got to take care of it, right? And so just, kind of fascinating there just to kind of see how this plays out. Again, I think it's there, right? I think, again, anytime people will take advantage of the system.
Yeah, I wonder if that was some of the same poll I was looking at from the Harris poll that said that 3 out of 4, that a lot of employers are satisfied with their PTO, but 3 and 4 say they don't use the maximum PTO. And they say the reasons that this is pressure to be available and responsive, as well as heavy workloads, were the top reasons for not taking more time off. So there you go.
Yeah, it sounds like the same poll, right? I mean, it sounds like, and again, I don't know, as a entrepreneur, what's time off?
Right. So, all right. You have anything else for us today on the news before we get into our story?
Yeah, I got one unbelievable thing. And that the headline just caught my eye, right? And so here's the headline: company that recruited workers with white-only job listing has to pay the feds pay up after a Fed investigation. So here, let me see if I can find the job posting. Here it is. So the job posting went up last year, and specifically it said this: recruiting workers who are only U.S.-born citizens, parentheses, white, who are local within 60 miles from Dallas, Texas. And then it says, in the parentheses, don't share with the candidates. And so somebody got that and said it and said, all right, I'm going to put that up. Now, the company blames it on a disgruntled worker.
Don't share with candidates.
Which doesn't surprise me. That would be a great disgruntled worker thing to do. But if those conversations are going on, I mean, it is 2024, Chuck, right? We haven't gone in some crazy time warp where we're back in the 1960s, right? It is 2024. The Civil Rights Act has been passed, right? I want to make sure.
Yeah.
And they were not the only one. There was another company. Let me see if I can find it. Paramedic, full-time, no African Americans needed. I don't know. I mean, again, I'm flabbergasted by this, but the point is this. We have Title VII, the Civil Rights Act, which basically says that we cannot discriminate based on race and color, and we need to be following it. This is a law, right? It's the law, and it's the right thing to do. I don't know if I can say that enough. It's the right thing to do. We need to be following it. And really, it should not matter. We should be judging the individual about how they're going to perform in the workplace. And it's so easy for us to get caught up and go, well, I don't know. Well, are they going to perform? I don't. What do you think, Chuck? And like, are you amazed, or am I just the only one flabbergasted?
It's amazing, but the funny thing is, don't share with candidates in parentheses. I mean, that's precious. That is like behind the scenes view. Hey, look, let's pull back the curtain.
Yeah.
And guess what? We screwed up, and we put it in writing, and now we're busted. And let's come up with some weird excuse that why it happened. So
yeah. And again, right? I mean, I don't know. So again, they're gonna have to pay a fine, and then also do, as you know, Chuck, right? They're gonna have to do training. They're gonna have to do racial sensitive training for all of their employees, especially those individuals that do the hiring, and rightly so. They should be doing that. Again, there's stories come up, and we can't say them enough. And again, this is where companies, right, intentionally are doing these things, and that's where we need to get after them. We need to be like, no, we're not going to allow that.
A boatload of material for the HR Stories podcast. I'm telling you, we report, you decide, but you need to do more than decide, folks. You need to listen, learn, and act. Don't make the same mistakes these companies did, or this next company coming up after this break, because it's a doozy. You think you can say and do anything about your employees, and let's launch it out there. And this person's an idiot for doing this. And guess what? You can't. Oh, but Chuck, what about First Amendment? Well, why don't you listen as we take a break here on the HR Stories podcast, where there's a lesson in every story. We'll see you in a few moments.
Hi, it's me, John, from the team at HR Stories. We are often asked, how do I get better at HR? The simple answer is by practicing it. But as with most things in life, it isn't that easy. We make the best HR decisions when we have the knowledge, the systems, and guidance in place. Chuck and I founded the team at HR Stories to help HR practitioners get HR right. We are passionate about giving you the tools to excel at your job. For more information about upcoming workshops, resources, and our latest blogs, check out our website at theteam@hrstories.com. Together, we are the team at HR Stories.
Welcome back to the HR Stories podcast, where there's a lesson in every story. Or as I like to say, and well, kind of just came up with this one the other day, HR Stories podcast, where the drama of the workplace meets the gavel of the courtroom.
I like that. The workplace drama meets the gavel. I think that's a good, good little tab there. Tagline.
I love that. Drop the mic. Wow, the crowd goes wild. And with that, I am your host, Chuck Simikian. And as always, I'm joined by my co-host, John, the T-Man Thalheimer.
Woohoo! I'm here as well.
Crowd goes wild. The T-Man. Anyways, today we are diving into a case that is pretty much as modern as it gets. It mixes social media, workplace rights, and get this, folks, a dash of constitutionalism, shall we say, into this debate. And John, we've talked about how social media can get people and companies into trouble. But today's story is where the rubber hits the road, shall we say. John, let's think about this. Okay. Having a Facebook post and it lands you in a federal lawsuit.
Yeah, that would not be good. Now, when I'm on Facebook, I try not to offend anybody. I try not to have somebody show up with my door going, "Excuse me, are you John Thalheimer? You've just been served."
Right, right. So, and that's a good good parameters to use. And today, though, we're talking about a town in Vermont, and Vermont's small state, small town. Everyone knows each other. Opinionated group. And in this story, it's a contractor named Bevins and Son, which, well, they found themselves on the wrong end of a Department of Labor lawsuit. It all started with a dispute over unpaid wages and took a turn into social media retaliation. Asian. Imagine being sued for what you thought was, hey, I'm just venting online.
Yeah, I mean, this is the digital age, and I think we get comfortable with like, you know what? I'm going to share this with the community that I'm in, and no one's going to mind, and no one's going to be offended, and then boom, somebody's defended. It definitely sounds like a digital age nightmare. Now, I don't know if you know this, Chuck. I don't think we've had this conversation. My aunt used to
Mm.
live in Vermont. Used to live up
Oh,
there in Newport, Vermont, up there in near the border of Canada, and really liked it. Really loved being up there, and just had a great life up there. And so
yeah.
I get it, right? Vermont's a wonderful state, but boy, this sounds like if the feds are there, it's a big mess.
Yeah. And listen, it all began with an employee complaint, like I said, about, and get this, for not getting paid overtime, which is a classic start to many of our labor disputes and many of the stories that we tell. But they settled the claim. And the company said, okay, we're going to settle this. They took to Facebook to air some grievances, and it didn't sit well with the Department of Labor.
Yeah, it sounds like this wasn't just a few posts, and it sounds like, and again, the feds are involved. There's something deep, and there's definitely going to be a lesson for us as we go through this story for sure.
Yeah, and it's going to be a lesson on the boundaries of employer speech and the protections employees have under the Fair Labor Standards Act. Today, we'll unravel how a social media post, can go from personal to prosecutable. And let's set the stage, shall we? So, Bevins and Son, they're well known contractor group in Milton, Vermont. And they found themselves in a pickle after their employee, Riley Bacchus, raised concerns about his overtime. Now, this is where it kind of gets a little sticky because Riley openly threatened to call the labor board, the mythical labor board, if his pay issues weren't resolved. And instead of addressing the issue internally, it did escalate quickly because after some back and forth, he got fired. They fired Riley, and he didn't take it lying down. He did call the labor board, so to speak, but he calls the Department of Labor, which triggered an investigation into the company's practices. So they have this big investigation, and Bevins and Son says, okay, we're going to agree to a settlement. Because a lot of times it comes down to that $25,000 in punitive damages and some back pay to Riley, plus additional funds. Okay, this is important, additional funds to other employees. Case closed, you'd think, right? But here's where modern technology, whirling dervish, throws in a twist.
It's fascinating, right? And I think, and I know what's coming, right? I know that somebody went on. You've been broadcasting this. You've been teasing us about this. Somebody went on and vented, didn't they?
Yeah, bingo. And so after the settlement, and this is where people take things personally, right? But after the settlement, the company officials couldn't help but express their frustrations on Facebook. They made several posts disparaging Riley, even implied, this is kind of important, that employees involved in the settlement were coerced into giving back their compensation. So just to replay that, Riley gets a settlement, right? And then the other people got settlements too, because then they're like, oh, maybe there's some other unpaid overtime. And so the company, as you'll find out, made a big deal, said, well, here's the deal. The other employees felt so bad, they gave their money back. And the Posts caught the eye of the Department of Labor, and they were not too pleased with them because it led to allegations that Bevins and Son used social media to retaliate against Riley and the others who were involved in the wage dispute. And it's basically a groundbreaking case because it challenges the notion that you can say anything online, even as an employer.
Yeah, and it's not about what you say, but it's about how you say it and who you're saying it to and all that stuff, right? And so it goes into all those things, and paying attention to that is important.
Yeah, and so the court had to look at a couple of different things, and they had to consider whether these social media rants were just personal expressions, okay,
Yeah.
or if they crossed the line into, and I underlined this metaphorically for our listeners that are listening, did it cross the line into retaliatory actions that could influence or intimidate other employees. It's a fine line in the digital age where a post can be seen by hundreds, thousands, tens of thousands, and then linger indefinitely.
I mean, think about that, right? Because now here I am, I'm an employee. I see my employer or my employee representative going out and saying these things about an employee that used to work there that went forward and communicated to the Department of Labor, right? And so I see that, and now I'm going to be like, I don't want that. I don't want to be that employee, right? And so it pushes me back from taking action, which I do have a right to take in there. And so we need to make sure we kind of dive into this and understand how the power of words can get the employer in trouble.
Yeah, and I'm going to jump ahead with a phrase that you'll hear me use in a couple of minutes: chilling effect.
Oh, okay.
Having a chilling effect, which kind of
Yeah.
summarizes a little bit about what you just went over. So the court's decision here could set a precedent going forward, reminding employers everywhere that the First Amendment has its limits. And that's what they basically said was, we got First Amendment rights to say this stuff, but it does have its limits when it comes to protecting retaliatory or coercive speech in the workplace. So as we dig a little deeper into the characters of the lawsuit, Riley Backus, the employee at the Storm, he was a hard worker. In all the court documents and all of the witness testimony, it said, look, this guy was a hard worker. He put in the extra hours whenever needed, and his role demanded it, especially in the busy seasons. But he wasn't just any worker. He was dedicated employee. He trusted Bevin and Sons would treat him right. And so he was really bought into the company himself. But after this discovery that not all his overtime hours are being accounted for, he did what many would. And he said, I'm going to go to my boss, who was Brian Bevins, hence Bevins and Son, the president of the company.
Yeah, that must have been a really tough conversation on both sides, right?
Yeah, absolutely. And we'd already covered that Raleigh brought up the issue. Brian Bevins was less than receptive. And instead of rectifying the mistake, Bevins dismissed Riley's claims, blew them off, and then later fired him, a decision that didn't sit well legally or morally. Now,
hey, Chuck, can I interrupt before you go on?
Yeah.
I'm curious, and maybe you're going to get to this in the story. Do we know why the company fired him? Like, what was their reason for firing him?
No, you know what? I don't think, did not get into that. I don't know if they gave a reason of job performance or anything. I think maybe they were just frustrated. Who knows? That's a great question. I did not see that in the documents as much.
Yeah.
But they fired him. They fired him, and then not only does Brian Bevins get into this, but there was a secretary and treasurer of the company, Tiffany Creamer. She plays a pivotal role here. And so the Department of Labor, laying this out, issues its findings, and the settlement is publicized. So she takes to Facebook herself, and her posts weren't just venting. She named Riley directly. She discredits him and essentially calling on the community to question his character and integrity. In this little town of, Milton, Vermont.
Yeah.
And it's here that the line between personal grievance and illegal retaliation are blurred. And I just want to point out, as we talk about in our listeners, she's the secretary and treasurer of this company, she's an agent of the employer, right? She's an agent of the employer.
Yeah.
And that's here where the line between personal grievance and illegal retaliation gets blurred. Like I said, the Department of Labor argues these posts were direct retaliation for Riley, against Riley, asserting his rights under the Fair Labor Standards Act. And even Bevins hinted in one Facebook comment that other employees, and I kind of covered this earlier, but it's important that I pull this out. Bevins, Mr. Brian Bevins, hints that other employees had returned their portion of the settlement, which, if true, could be seen as coercing employees to give up their lawful compensations.
So this isn't right, Chuck. This isn't just about a disgruntled employer, right? It's about setting a precedent on how far an employer can go to reacting to an employee's claim in social media, right?
Yeah, right you are. And the courts had to consider all of these nuances. And it really does come to those nuances, the personal vendettas aired publicly, the potential coercion, and the chilling effect these actions might have on other employees. Oh my gosh, if we bring up a problem at work, they're gonna slay us in the community. They're going to besmirch our name, right? So it's a textbook example how modern challenges like social media use intersect with workplace laws.
Yeah, it's so complex. I have to say, Chuck, I just think about why would you go on social media after a complaint and just disparage somebody? I don't get it. I don't understand why anybody would do that. But I think you hinted at it before. It was personal to them, right? It was personal. Yeah. This employee had worked for them probably for a long time. They had a good relationship with this employee and were probably pissed off that he went and did those things. So what can we as employers take away from this case? What should we take away?
Well, there is a little bit more that I want to kind of talk about, because the focus, there were some legal intricacies in this. So after the initial lawsuit was filed by Department of Labor, Bevins and Sons, along with Tiffany Creamer and Brian Bevins, they sought to dismiss the case, right? And that's one of the things that I want our listeners to take away from this is they argued that their posts on Facebook were protected under the First Amendment free speech.
Yeah, it sounds like a solid defense, right? Constitutional says we have free speech, right? It's a cornerstone of American values, kind of.
Yes, absolutely. But this case wasn't straightforward as claiming free speech. The court had to consider whether the First Amendment shields employers from retaliation complaints when they use speech as a tool for retaliation. So we've kind of pushed that, and I wanted to make sure everyone really understood it. But ultimately, the court concluded that when speech is used specifically to retaliate against employees for exercising their rights under the Fair Labor Standards Act, that speech isn't protected. So there's kind of three levels there, John. And because someone's saying, well, why can't I say, I don't like this restaurant, I don't like this person? Well, you're a person talking about a business. This is a business talking about their employees that were exercising their rights under the law called the Fair Labor Standards Act.
Yeah, that's fascinating, and I think that kind of ends up right, and so it kind of ends up, and this kind of just pushes Bevins and Sons' defense strategy. Right, it's over. Right, again, it's over. Kind of looking at how to deal with that.
Yeah, it was, and just kind of getting more to the conclusions here. The court's decision underscored that critical aspect of employment law. While employers are free to communicate openly, they can't use that freedom as a shield to engage in unfair practices. Facebook posts by Tiffany Creamer, which were derogatory, it just crossed the line.
Yeah, and I mean that's a great. I mean, again, it's right. It's setting the stage, and that's going to clarify for us, like, okay, what can we do and what can't we do? And it makes sense, right? I mean, typically when we think about First Amendment, we have a First Amendment right from the government not to allow us, freedom of speech, right? We have that freedom of speech. The government can't stop us from saying it, and so they're like, okay, well, the government can't tell us for saying we can't say this, but there is. There's limits to that, right? There are limits,
Yeah.
and we can't use it to retaliate against somebody in this manner, which is going to have a chilling effect, right, on the other employees.
Yeah, and I talked about Milton, Vermont, a small town, down to the local coffee shop. There was actual community reaction to this too. Community members rallied. Some actually rallied behind Bevins and Son, praising their honesty and straightforwardness. That's the Vermont way. Is that? I don't know if I'm doing a good Vermont accent,
No,
but hey, they're straightforward. They're honest. And others were appalled by the apparent vindictiveness of the posts, and it did stir up a lot of debate at the corner coffee shop and throughout town about the rights of employees versus the rights of employers.
And it's probably a good conversation to have if you're having it in a good manner, trying to figure out what's the thing. I just, as an employer, I always tell this people in my classes, right? As an employer, we have certain rights, but we also have certain responsibilities. And so we have to make sure that we're following through on those responsibilities. And one of those is not to have a chilling effect, not to retaliate against our employees when they're going after their rights, right? And so kind of doing that as well. And so it sounds like this is going to have a ripple effect, not just this lawsuit, not just in Milton, but maybe across the country.
Yeah, it could. It sets a precedent that could affect how employers across the nation think about what they post on social media concerning their employees. But John, what do we always do here at the HR Stories podcast? We go through some best practices for companies to avoid these similar fates. So what can you learn? I've got a couple of things here, a couple of bullet points. Number one, and it's not rocket scientists. Rocket science. It's not. It's not brain surgery. It's really the same stuff you and I talk about all the time. Number one, educate and train your management. Make sure everyone understands the Fair Labor Standards Act. Provide training on what constitutes retaliation. I mean, I'm real big on telling people we cannot appear to retaliate, even if it's the right thing to do to address something that looks like retaliation. It could come across.
Yeah, and I just want to while you're talking, before you get into bullet point number 2, sorry to interrupt. I do want to say one of the things that we do well at the team at HR Stories is we train managers to make sure they're compliant with the laws. That foundational compliance is something that's missed in a lot of leadership training, right? We go on to talk about time management and difficult conversations and performance management and all that. But if they don't understand compliance, you're going to end up with employees in the HR office. You're going to employ up supervisors in court. And this is why that training is so important. So go ahead and reach out to us. If you need your managers to be trained, we have a couple of different ways we can do it. We can do virtual. We can do individual coaching, whatever you need. Just email us at team@hrstories.com. We'll get back to you as quick as possible.
There you go. Number 2 is develop clear policies. Goes without saying. Implement clear anti-retaliation policies and make sure the policies are well communicated to all employees. Establish a reporting mechanism, that's safe, confidential process, and ensure employees know how to use the process. There's a little theme there, John. Create a policy, but communicate the policy. Create the reporting mechanism, but make sure employees know how to use the reporting mechanism. Number 4 bullet point is monitor social media usage. Advise your managers, employees on the appropriate use of social media. Monitor public social media posts from your company for any potential retaliatory comments. And then finally, one thing we always say is respond to all complaints. Take all complaints seriously and ensure that there's action because you don't want to have, you want to make sure everything, your response to complaints are fair, documented, and non-retaliatory.
Yeah, and I think those are fantastic 5 really smart points that kind of drives it home. The things we say all the time, Chuck, right? Train, educate, do it right, make sure you're paying attention. Those are the things that we should be doing about any of the policies. And I just think retaliation is one of those things, and we've talked about it in a couple of podcasts, that employees don't focus on or employers don't focus on when they should.
Yeah, absolutely. And once again, the Bevan & Sons case serves as a stark reminder of the importance of these practices. Companies that fail to implement and uphold the standards not only risk legal action, but also harm their reputation in the in the community and within their employees.
Yeah, and again, right? Again, I think it's important to kind of think about that, right? Because when your reputation in the community goes down, getting hired is harder, getting jobs is harder, right? And so it becomes really bad, right? And so kind of doing that. And our listeners, whether you're in HR management or an employee, it's essential to understand your rights and responsibilities in these situations. We hope today's episode shed some light on the complexity of the Fair Labor Standards Act and the importance of protecting employees' rights in and outside of work, right, in the social media sphere as well. Join us next time as we explore another intriguing case with valuable lessons for the workplace. Until then, remember, with the HR Stories podcast, there is a lesson in every story.
And as I said earlier, and especially in this case of drama, where the drama of the workplace meets the gavel, I don't know, have a gavel of the courtroom. Drop the mic.
Thank you for listening to the HR Stories podcast. The material presented in this podcast is for informational purposes only. Chuck and John always recommend using an employment lawyer or HR consultant to handle any legal concerns or HR issues. We do our best to double check sources and make sure the information we are providing is accurate. We may eliminate or embellish without changing the basic narrative to make the story easier to understand. In certain circumstances, we may change identifying information to protect the innocent. The HR Stories broadcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the hrstoriesteam.com and learn more about how the team at HR Stories can support your business or nonprofit. Thank you for listening to the HR Stories podcast, where there is a lesson in every story.